Succession. 1. Jurisdiction in succession. 1.1. The basic general rule and its variations. Articles 4 to 9. The succession as a whole will be subject to the jurisdiction of the courts of the member state where the deceased had their habitual residence at the time of death. This rule comes with a number of exceptions, specifically as regards the choice of court and choice of law. Where the deceased has chosen the law of the state whose nationality they possessed at the time of making the choice or at the time of death to govern the succession, the courts of that state may be chosen by the parties concerned to have exclusive jurisdiction. It is notable that the deceased is in this instance not one of the parties concerned. Therefore, a direct choice of court made by the deceased, say in a will, does not fall within this rule. However, where a choice of law has been made in the will, this may have effects as regards jurisdiction in the succession. The regulation contains subsidiary rules whereby a court or the courts in the member state whose law had been chosen by the deceased to govern the succession may have jurisdiction by virtue of a choice as noted above, or where a court in the member state of the deceased's last habitual residence declines jurisdiction in their favor, or where the parties to the proceedings have expressly accepted the jurisdiction of the court ceased. Finally, apart from the foregoing rules, jurisdiction may be based on appearance by parties in the proceedings who had not exercised the choice of court. 1.2. Meaning of court, Article 3. It is a very significant feature of the regulation that the definition of court is much broader than the meaning usually given in EU civil law instruments. In addition to judicial authorities competent as regards matters of succession, the term covers other authorities as well as professionals with such competence provided that they act or exercise judicial functions under powers delegated from or are under the control of a judicial authority. Such other authorities or professionals must also guarantee impartiality in carrying out these functions and be subject to review or appeal by a judicial authority. Their decisions should also have a similar force and effect as the decisions in these matters of judicial authorities. The member states are to inform the European Commission as to which authorities and professionals in their states come within this description. 1.3. Jurisdiction. Further provisions. Articles 10 and 11. Courts of a member state may have jurisdiction in the succession of the estate of a person whose habitual residence at the time of death is not in a member state of the European Union. If there are assets of the deceased's estate there, and either the deceased had the nationality of that state at the time of death, or failing that, the deceased was previously habitually resident in that state for a period ending not more than 5 years before the court is ceased of the matter. If there is no court of a member state with jurisdiction on this basis, the courts of the member state where assets are located will nonetheless have jurisdiction to rule on those assets. There is also a final fallback rule, where no court of a member state has jurisdiction by virtue of these rules. In such a situation, exceptionally, the courts of a member state will have jurisdiction in the succession if it would not be possible for proceedings to be raised in a third state with which the succession is closely connected. This rule on forum necessitatis should ensure that there is always a court of a member state available to deal with matters of succession. 1.4. Jurisdiction in relation to acceptance or waiver of a right of inheritance. Article 13. A further important rule in the regulation determines jurisdiction where a person, under the law which is applicable to the succession, makes a declaration before a court about one of the following: acceptance or waiver of the succession, acceptance or waiver of a legacy or reserved share, limitation of the liability of that person with respect to the liabilities of the deceased person's estate under the succession. Under this rule, the courts with jurisdiction are those of the member state of the habitual residence of the person making the declaration, provided that under the law of that member state, such a declaration may be made before a court. 1.5. Assets located in the third state. Article 12. Where in the deceased's estate there are assets located in a third state, that is, a state which is not a member state of the European Union, or, as in the case of Denmark, Ireland, and the UK, a member state which is not bound by the regulation, a court which is seized in the succession may, if so requested by a party to the proceedings, decide not to make a ruling as regards any such asset, if any decision which it might make in respect thereof is likely not to be recognized and enforced or declared enforceable in the third state concerned. Effectively, in such cases, it means that in respect of those assets, separate proceedings will have to be raised in the third state where they are located. This rule is without prejudice to any rights of parties under the law of the member state of the court seized to limit the scope of the proceedings.